Well, welcome everyone. Thank you for coming. Come on in. My name is Dr. Ryan Whalen. I'm the director of CILS, our Center for Interdisciplinary Legal Studies here at HKU Law. And I'm really happy to welcome Jacopo Martire to present his new piece of research, a piece that's, I believe, in progress right now. So you have a chance to sort of see it before it's in its final polished stages, and perhaps help think through some of the things that Jacopo is going to be writing about in this paper. I won't do an effusive introduction. All you really need to know is Jacopo comes from Bristol Law School, and I think it's fair to characterize yourself as sort of a Foucaultian,
yes,
in terms of your research approach. And that is a type of legal research that the Center for Interdisciplinary Legal Studies is very interested in. We're interested in all sorts of intersections with different sort of bodies of theory and different bodies of methodology and ways to think about the law. So we're really lucky to have Jacopo here to introduce this style of research to us and discuss his his paper rather, about the hard problem of AI in law. So let's give him a quick little introduction and let him take the rest of the hour. I will say, you can save time for comments. You can go as long as you want or as short as you want.
Okay, thank you very much, Ryan. It is an absolute pleasure to be here. Thank you for having me. It's been a desire of mine to come to Hong Kong and to present my research in this very lively intellectual environment. And so thank you very much for that. So without further ado, I think I will speak about 30, maybe 40 minutes. And again, if you want to interject, you can. Otherwise, I can try to answer your questions later. So the hard problem of AI in law. I mean, I have to click. Okay, right. So surely AI is having a tremendous impact on our world, and surely it will have progressively an enormous impact on the legal discourse. Legal discourse, both understood as the practice of law and the theoretical conceptual framework that we have when we use law. And surely AI is posing a lot of problems to academics, practitioners, both in the judicial and in the practice branch. And a lot of these problems are very urgent problems that need to be addressed, and luckily are being addressed by a lot of colleagues with a lot of acumen and responsibility. But I think that there is one problem that I would qualify as the hard problem of law that has not been yet entirely delineated. And I think it is important to see what this hard problem is in order to start ourselves preparing for dealing with it, basically. So here you see basically the abstract. I have this quite scarce, quite simple style of slides so that we can speak more and you don't read too much, hopefully. And I think that we can distinguish problems very similarly to what Chalmers said about the difference between easy and hard problems with regards to consciousness. I am pretty sure that you don't know what I'm talking about here, so I'll just explain in very simple terms. David Chalmers is a philosopher of mind. And in 1996, in a very famous conference, he stood up on podium and asked, look, guys, we all are dealing with a lot of problems with consciousness, like how do we memorize things? How do we process information? How do we recall information? What exactly is memory? What exactly is understanding? And so on and so forth. How our brain works. And all of these are very important problems, and sometimes devilishly complex from a technical point of view. But all these problems, at least, can be addressed with the kind of conceptual framework that we have, with the methodologies that are at our disposal right now. we have with enough computational force, basically, we can reach the end of the conundrum. We can have a positive or a negative answer to all the questions that we have. But, he continued, there is one particular problem that is impermeable to this kind of analysis. And this problem, he termed the hard problem of consciousness. What is it? The hard problem of consciousness can be described as the difficulty in figuring out why we have what we can call experience. What does it mean? We can datify much of what we understand about the world. We can absorb information, and we can say that, we absorb some particles for our sense of smell, that some precise wavelengths create some colors in our mind, and so on and so forth. But one thing is to say that these data exist outside and they are processed by our brains and our sensory organs. And one thing is to talk about the experience of those. To let you understand a little bit more clearly, let me use the very famous Mary's Room theoretical experiment. Have you ever heard about this, Mary's Room? No? It's a very interesting thought experiment. It says, imagine Mary. Mary has lived all her life in a room. And this room is all black and white. There's no color whatsoever, right? Maybe they used some particular kind of lighting. Maybe they painted everything black and white, included Mary. But all that she's ever seen in her life is black and white. However, Mary has had access to a computer linked to the external world, and this computer has access to all the knowledge available. And Mary has been obsessed all her life with the color red. She has read everything that there is to know about this color. The history, the literature, all the books that mention red. She can name every single object that exists that is red, that she knows about, of course. She knows the wavelength, how red is basically can be created through pigments, and so on and so forth. She knows everything, from the most minute details to the most theoretical ones. However, let's imagine that at a certain point we open the door and we let Mary out. She will, for the first time, possibly see something that is red. She will have the experience of red, right? Will she know something more at this point? Will she have something more about the color red? The answer is, of course, she will have the experience of red. But the experience of red, of course, is something more different, like in natural, in ontological terms, in what it is, from knowing the data about red, right? This is the hard problem of consciousness. Now, what it is, the hard problem of law, of AI and law, sorry. The hard problem of AI and law is simply this, is a problem that upends completely our theoretical framework in law. All the concept that we use to talk about law, to apply law, to practice law. Law is made out of concept, right? Law is not a thing like water and glass. Law is a discursive practice. We have convened on some meanings of some words, and through these words and meanings, we apply to reality and we transform reality. We manage it, right? And this movement is very slow. We always adapt our concept. Most of the articles that you read are readaptations of this concept, right? And of course, AI is forcing a lot of readaptations. But I claim that AI will eventually force one readaptation that will basically hit at the root of our legal discourse. It will basically undermine the concept of human dignity that is at the basis of our legal edifice. And if that falls, everything falls with it, like a game of cards, house of cards, sorry. All right? Are you with me so far? Any questions? We're good? Let's move on. So, have you studied jurisprudence yet? No? Yeah, no, you want to forget about it? Mm-hmm. Yes? All right. There's this phrase that is really at the beginning. I think it's the first phrase in Law's Empire. by Ronald Dworkin. He starts magniloquently by saying, "We live in and by the law." Very beautiful quote. Well, probably in a few years, we will say we live in and by AI. AI is literally changing the environment. And as the environment changes, we need to change our concepts. We need to change our ideas. We need to change our basically software to deal with the hardware that is the world around us. And this creates disruption. Roger Bransford, which is one of the foremost scholars in the field of law and technology, has said that technology brings along waves of disruption. And algorithmic governmentality, AI, things like that, because they will apply to the whole of the environment that surrounds us, from things like medicine to the, I don't know, flights of planes, to the way in which you receive your suggestions on TikTok and whatever, it is probably the technology that most will create disruption. It makes sense, no? And he says that this disruption comes in waves. It doesn't come like a bomb all the time. It's not a lightning, it's waves. And he says the first wave is when we created spaces that didn't exist before. And so we had to regulate it. The cyberspace, that's a classical example, right? The cyberspace is a little bit like a public space, but it's very different from a public space. And it comes along with a series of challenges. But he says, so far so good. We're scholars, we are good at this, we have always done this. We always, as humans, invent new things, new technologies that change the environment, and we catch up. That's what the law does. A little bit frustratingly, if you think about it, law is always one step behind. But when it catches up, it does a good job. Then there is the second wave. And the second wave is when we realize that actually machine will regulate society better than human can do. Again, this is an exercise in futurology. Ryan warned me, Jacopo, this is not here anymore. You should make this very, very clear. And yes, it's absolutely true. This is an exercise in futurology, in trying to see where we're going. All right? And so let's imagine that at a certain point we have machines, and this is Roger's preoccupation, will, through structuring of our environment, will prevent us from doing bad things. Like, for example, if you're drunk, your car doesn't start. You want to do some financial transactions that are shady, the computer will not allow it. Maybe you want to post something nasty online. The algorithm will read through it. It already does to a certain extent, and prevents you from doing that. Maybe it blocks you. At this point, we are at a bifurcation. Either we keep allowing individuals, the human, to regulate, to manage law, to write law, to apply it, with all the pros and cons that are linked to that, or we let the machine do the work. And he says this is a second wave. It's much more important because it literally changed our relationship to the law in ways that are not like this before. And he says if this second wave comes to pass, then we have the third wave. And the third wave is basically because computers are smart machines, AI, whatever you want to call it, are dealing with law. Please. Please don't fear interrupting me. Then all the human-centric concept that we have in law, like trust, due process, fidelity, they go out of the window, right? Because it's a computer doing it, not us. We have to really fundamentally readjust them. And I'm saying that basically we're already in the third wave and we're caught in its riptide. Technically speaking, rip current, but riptide has a nicer ring to it. And so let me try to explain what it is that is actually the hard problem and why it is connected with this third wave in ways that I don't think Roger completely captures in his own article. It's published from 2022. If you want the reference, I'll give it to you. So let's start by dividing between easy and hard problems. okay? And as you can see, I already gave you a little bit of Chalmers. And let me give you a very, very clear caveat. When I say easy problems, I don't mean simple. I don't mean piece of cake. They are extremely complex. And for most of them, I would be out of my depth completely. The overwhelming majority. Great colleagues are working on them. But they're working on them with the theoretical tools that we have right now, and they're making slight incremental steps. They're readapting, they're changing. But the hard problem is something else, is something that really will require a paradigm shift, a complete overhaul of our legal vocabulary and conceptual framework. And again, remember, concept is what makes us do things with things, right? You have a concept of water, and that's why you're related to water. You have a concept of friendship, and that's why you're related to your friends. You have a concept of ownership, and so on and so forth. I guess you get the idea. It's fairly simple. So what are the easy problems in AI and law? I'm still struggling about this distinction, so if you have comments, please. I would like to divide between trivial easy problems and non-trivial easy problems. Again, please don't take the word trivial as a kind of normative judgment. It's just a placeholder, and if you don't like it, I promise I'll change it. Trivial easy problems are problems that are related to the technical nature of algorithmic governmentality, of smart machines, of AI. But once they are translated into the legal discourse, they appear fairly simple. Again, things like bias, efficacy, computability, while extremely important, that's why trivial here doesn't exactly do the trick. From a legal point of view, I would say are fairly trivial. If the kind of information that we have fed to the system include bias, then the decision made by the system, like for example in granting or not a loan, or by allowing someone on an airplane or not, or by granting parole or not, those decisions are illegitimate, right? If there is bias, illegitimacy. If the system is inefficient, then why use it? If it is non-transparent, why use it? Again, extremely important, figure out how the two things are connected. Extremely important translation work between computer sciences and legal sciences. And here we need to be very, very grateful to the guardians of the citadel of law in some sort of way that figure out this kind of intruders and say, no, 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 this doesn't work. And then there are non-trivial, and this problem, again, from a theoretical point of view, from the conceptual point of view, I don't think they present any kind of challenge, right? Non-trivial problems, on the other hand, are a little bit more complicated from the conceptual point of view. And these are basically the kind of thing that we deal when we deal with law as scholars, and also you as students in some sort of way. So I define non-trivial problems into three different categories, okay? So usual is your problem. Adapting familiar legal concept to AI impacts. So things like copyright, liability, privacy. You can immediately see how AI is severely changing the landscape and how we need to adapt. And it's a difficult adaptation because AI is creating things in the environment, in the world, that didn't exist when all these rules were created, and therefore require an adaptation. Again, sometimes very, very difficult. Think about copyright, authorship of AI-generated content. I ask AI to create an image. The image is created. Who is the author? Me? The AI? The coders? All together? liability. If the automated vehicle crashes, who is responsible? Privacy. Again, we have a complete different idea now of what data are. Before, your name, your sex, your height was something important. Right now, how many times you click on a certain website is even more important. How many steps you take per day. Where do you go? And so, of course, the concept of privacy requires a lot of work, right? We are dealing with a different thing, a different privacy. The concept needs to adapt. They're usual because this is what scholars do all the time. The world changes. We need to change the language. We need to change the concept. We need to change the practice. So these problems do not demand us to radically rethink, overhaul, or abandon our traditional concepts and their cognate practices. Rather, they lie more towards the most challenging end of legal business as usual. Okay? Because it's not the legal business as usual, like apply the law to the concrete case as it always happens, but reform the law a little bit. Usual easy problems. Regulatory easy problems. Algorithmic governmentality, AI, smart machine, I still undecided which term to use, create the world, right? They're literally creating a lot of stuff. For example, ChatGPT has already created so much text that now ChatGPT is using its own text as part of its large language model in a kind of echo chamber, almost like a reiterative process. And so, of course, we need to govern this thing. And this is a new thing. It is a new phenomenon. We need, which poses new challenges, different challenges. We need to adapt. Here are two examples. On the one hand, we have Brownsword. And of course, Roger, as always, is very much concerned with framework problem. He's a legal philosopher, after all. The Sheffield School of Natural Law Theory. And he says that whatever we do with new technology, especially AI, whatever we have to do is to protect the ethical agency of individuals. And you do this by protecting the common ground. First of all, the conditions of human life. Secondly, the conditions for meaningful self-development and agency, basically allowing individuals to express themselves, to reason, to act properly. And then the conditions for moral development of agents together. So how do we decide what to do? This might sound familiar. It's constitutional law, right? It's a variation of constitutional law. It's a fundamental rethinking of constitutional law, but it's constitutional law. That's it. Again, I'm not disparaging Roger. Roger is doing excellent, fantastic work, as Balkins and Pasquale are doing, by saying, look, we need to understand creators of AI as information fiduciaries. They use a lot of information that comes from people, and they need to use this information in a proper way. So the four laws, actually the laws are the last two, the first two are premises if you really look at it. But the idea is that if you're processing such a large amount of data, you cannot externalize the harms. Basically, you cannot let others suffer or pay the consequences of your processing. And we need to know who you are, because if you don't know who you are, it's the Wild West. As Balkin says quite explicitly, this comes from administrative law. Again, a little bit more fundamental, a little bit more structural, but still, I would say, uneasy problems. Please note the air quotes. And then we have what we could call the limit easy problems. And these are deeper challenges to establish concept. When the world changes, we need to adapt our concept. This is probably the 10th time I say that. But we tend to stick with our concepts because concepts are very powerful things. They've allowed us to do a lot of stuff, and they're connected with other concepts, and they're connected with ways of thinking, with our practices, with our habits. We don't want to give up concepts. We try to keep them. And therefore, when we face a challenge, we want to really home in on what that concept means and what that concept does and try to defend it. Again, this makes sense. It's not just an irrational knee-jerk reaction. It is what we have to do. It's the right thing to do. I think that one of the best examples here is a human adjudication against algorithmic decision-making, something that Brown mentioned in the second wave, right? So, for example, Hildebrand, Karen Matten, Baron Moses, Bernard Marquez, and Anderson, they've all posed problems saying, look, even if we would allow machines to decide cases, to read like a kind of logical tree, legal text, and to apply them to the fact, which is immensely difficult. I mean, but I'm not concerned here with those trivial problems, because these are problems that are for computer scientists. But let's assume that there's a genius computer scientist that create a machine that can read all the law and understand all the facts better because of computational force than any other judge. Again, you have not studied jurisprudence, but this is something, a thought experiment by Ronald Dworkin. Again, Ronald Dworkin said, you know, guys, there's always a right answer in law, because imagine this judge, Hercules, which is a demigod, capable of thinking more deeply than anyone, longer than anyone, knowing everything better than anyone. They will know at a certain point what the right answer is. This is controversial, of course, but you get the point. These authors say, even if we get to that point, what the computer would do is something different from what a human would do. Why? Because AI, by basically datafying human language, lacks the openness of unforeseen circumstances. Judges have a kind of internal point of view when they apply legislation. They feel the duty to apply legislation. They in some sort of way sense that individuals have a duty to obey the law. Judges build trust precisely because they're humans, and so you generally trust humans because they know what it means to be alive and to be a subject of law. And they're also role reversible. So the people that will apply the law will also know that those laws are applied to themselves, and probably this will create a kind of almost precautionary principle, right? So instead of discarding concept, as I said, we try to refine them as they're doing, codify a little bit better, although here codify is probably a nasty word to use, and to hopefully defend, if it is a thing to be defended. This is open, but at least we know what we're talking about. We're not confused. We say, oh, a judge and a person, it's the same thing. No, it's not the same thing. Computer, much more computational power, but. However, as I said, I don't think that this all requires a complete overhaul of our conceptual framework. I think that the hard problem lies elsewhere, and the hard problem lies here. And again, sorry if this is a little bit too wordy, if you have ways of reframing this. I tried ChatGPT, it didn't do a good job, I have to say. Failed. So, if human dignity is at the core of our legal discourse, and if we understand human dignity as the capacity that individuals have to advance claims concerning their life and the environment that surrounds them, then the evolution of sufficiently accurate predictive AI would fundamentally undermine the very possibility of an individual to advance authoritative claims about oneself, and therefore radically threaten our concept of human dignity. In other words, if the machine knows you better than you know yourself, how can you advance any authoritative claim on yourself? Do you see what the problem is? Any clarification needed? Sure? I can clarify, yeah? This is my job. All right. Now, if you see the statement has a few ifs. And so I need to prove a few things. One, if human dignity is at the core of our legal discourse, this is the first if. And if we understand human dignity as the capacity of individuals to advance claims, because this is a particular conception of human dignity, right? And of course, if the machines will get there, but again, this is a trivial problem. We're not very interested in that. And then I think another thing I need to clarify, to address is, what does it mean to know? What does it mean to know for a machine? What does it mean for a machine to know an individual? What does it mean for an individual to know themselves, right? Again, this goes back to Mary's room. One thing is to know the data. One thing is to have the experience. So, is human dignity as the core of modern legal discourse? Well, this is maybe the easiest thing to do, because more or less there is an agreement on this. It's a pretty hazy agreement. The contours of the agreement are not very easy to delineate. There is debate of what human dignity is even, but human dignity conceptually has had this function. One, is the foundation of our legal system because it reflects the inherent worth of human individuals. Because there is inherent worth, we are all equal. So equality only exists if we accept human dignity as the foundational concept. Second, it is a metric. Only a system that respects human dignity, whatever that is a system that is healthy, is a system that is doing what law should be doing. And here there's plenty of literature. Lon Fuller is the one that comes to mind. It's also an ideal. We should strive to human dignity, to protect human dignity, to foster it, to investigate it. I think that human dignity, most importantly, is having another fundamental function, which is this. It's a kind of empty space. Precisely because we don't exactly know what human dignity is, it is the kind of empty space that keeps us engaged one with the other, discussing who we are as human beings. Precisely because it's not sanctioned in some materialistic way what human dignity is, all our disagreement can be met there. It's a kind of direction, a kind of point horizon. In this sense, it is the core, but it's the empty core of the modern legal discourse. And it's a good thing that it's empty, because if we would fill it, then of course we would have to exclude a lot of things, right? It's a little bit like the concept of democracy, but democracy is more a procedure. Democracy is how we get to discuss about human dignity, right? Are you following me here? This is probably the most theoretical point. So the idea of human dignity has played the role of master signifier, a concept that, devoid of a precise meaning, is used to give significance and weight to all other concepts. The key here is it is void. Human dignity, precisely because it's not been rubber stamped by somebody, is still open to contestation, and contestation is what makes modern law. Okay? Contestation within reasons, of course, because there is always a balance. There's contestation and counter contestation, and so on and so forth. But I hope that this makes sense. If human dignity, whatever it is at the core of our legal system, well, what is it, human dignity? And again, here I'm not giving a kind of substantive idea. So I'm rejecting the thing like, oh, bodily integrity is human dignity. The existence of life is human dignity, and so on and so forth. I'm having a much more discursive and therefore open approach to it. Human dignity, it is normatively appealing because it's a counterbalance to the universalistic immateriality of law. What does it mean? It's very simple. You as individuals, seen by law, are not individuals. you are a legal persona. You are legal subjects. And a legal subject is universal, right? It's a kind of abstraction. It's general. No one here is a legal person, and yet all of us are. And so, in order to paper over the distance between the universal of law and the particularity of the individual, we do need human dignity as an open concept that keeps us asking. You know the story. You know the story. Women, for a long time, were excluded, basically, from the universe of law, if not as objects. Minorities were. Right now, we keep excluding. Like, for example, we are debating, actually, if animals have rights, if nature has rights, if the common goods have rights, and so on and so forth. But we can do this only if we keep human dignity as this kind of empty signifier. And it is important to keep it as an empty signifier because it allows individuals to step forward and to say, I am. I have this need. I want this thing. I am a person. Right? Always remember the Haitian Revolution, the only slave revolution ever to succeed against the French Empire. By Toussaint de Louverture, this amazing revolutionary that, having read the Declaration, Universal Declaration of Man and Citizen, went to the French authorities and said, guys, we're all brothers now, right? And the French said, not really. We really meant white people there. So, yeah. And there was war. Again, rights are never gotten by kindly asking. But at the core of the asking is the claim of I am. So Feinberg says to respect a person is simply to think of him or her as a potential maker of claims. Forst, which is a scholar of a student actually, of Habermas, dignity evolved to level social ranks, extending rights to all individuals. And it is about question of justifiability. When we do things to other people, we need to justify them because we're facing their claims. You don't justify yourself in front of, I don't know, washing machine. Although we do speak with our computers, don't we? But we have to justify our decisions towards other human beings because they have a claim. They say, I am, and you say, no, you're not. Because, and hopefully, the bridge between the universal and the individual is built, right? This is basically adjudication. This is what judgment does all the time. So to be a human in a proper existential sense of being a human being among other human beings, we necessarily need the capacity to say, I am. Once I say I, you can recognize me as something that is similar to you. This is why Asimov titled this very famous little short story, I, Robot, that was then translated into a terrible movie called The Bicentennial Man, I think. Horrible. But you get the point. Are you following me? Good. So this is basically the hard problem, right? AI may challenge human dignity through these two routes. One, self-knowledge. Individual loses authority over their identity. Again, if a computer can profile you and read you and predict what you're going to do better than you can do yourself. And it can, and you know, there is an assumption, a presumption that it can do it better because it has more computational power. It knows more about you. He has tons of data. Then, how can you say, I am? Before, there was exactly the same problem, right? You go in front of a judge and you say, I am, and the judge say, no, you are, and you reply, no, I am. It was always a kind of, skewed game, right? Because you cannot just decide who you are. You are who you are through the eyes of law, and law has been written much before you were born. but the scales were not so obviously tilted. We were all in the dark when it came to who we were. Let me read you this quote from the beautiful book on BS by Harry G. Frankfurt, which you should read. It's a very tiny book, very, very nice. And it's about BS. What is BS? It's basically, can I say bullshit?
You can say whatever you want. Safe
Bullshit.
space.
Bullshit. The book is called On Bullshit. And Harry G. Frankfurt makes a difference between lies and bullshit. Lies are the things that you use to basically invert reality. Were you there? No, I wasn't. But you were. Bullshit, however, it's basically everything that you say to divert the attention to that is not on the line of truth and falseness, is somewhere else. There's a very interesting quote. Never say a lie when you can say yourself with a ton of bullshit. Right? I guess that I hope that you get the difference between lying and bullshitting. You're not exactly saying the opposite. You're just saying something that we never know if it's true or false, and it doesn't really matter. And yet, it occupies our mind until we're too tired. And Harry G. Frankfurt makes, at the very end of this book, this quote, which I think it's particularly interesting here, because it says this: there is nothing in theory, and certainly nothing in experience, to support the extraordinary judgment that it is the truth about oneself that is the easiest for a person to know. Facts about ourselves are not particularly solid and resistant to skeptical dissolution. Our natures are, indeed, elusively insubstantial, notoriously less stable and less inherent than the natures of other things. And insofar as this is the case, sincerity itself is bullshit. Of course, here we can substitute sincerity with claims about oneself. But again, before AI, everybody was basically talking some kind of bullshit. Actually, we had to give people claiming who they were a certain kind of authorship, right? I might know who you are, but your opinion about who you are matters intuitively. But right now, that changes completely the game, right? And if it changes completely the game, then human dignity is out of the window. And if human dignity is out of the window, wow, everything else that is rooted on human dignity is out of the window, right? And this brings me to the other problem of the communication breakdown. You can make claims only to another individual that has the same existential experience as you. Broadly speaking, very broadly speaking. Like right now, we're talking and we're sharing experience. Of course, we have very different lives, we have very different conceptions. We're raised with different languages, right? But I am pretty sure that you are humans. And yet you've gone through some things that were similar to the things I've gone through throughout my life. I think that there is an overlap. But again, as we said earlier, you don't talk to a washing machine. You don't speak to an elevator. You might yell at a computer, but you well know that the computer doesn't get it. And so if this is the truth, there's no reciprocity. You're literally speaking into the void. Your experience is not datafiable. It can be predicted, but it's not datafiable. Remember Mary's room? I can know everything about you. I can know why and when you will fly from danger, but I don't know how it will feel for you. And that is definitely important because humans are the only entities into the world, as far as I know, and as far as I'm certain, that act on the basis of two things: causes and reasons. Causes are material: gravity, electricity, electromagnetism, the blood flowing through our veins. Reasons? It's our commitment. It's what we do because we believe we have to do it. And if you think about it, It's most of what your actions are based on. And of course, reasons are ineffable. I don't really know why you do the things you do, but you can reconstruct them and you can communicate it to me. And I have probably my experience database, something very similar. This is why, for example, it's pretty easy to judge normal people, healthy people, and people that are affected by severe mental illness, because their reasons are so skewed that we cannot get them. But still, it is a bit easier than to talk to a machine, right? And so, this is the problem. If machines are capable of knowing us in this kind of predictable way, and again, we need to ask, do we ever cared about knowing the defendants, the claimants? Is this something law was ever interested in? But if this happens, then, of course, human dignity is threatened in a way that has never been threatened before. It doesn't make sense to speak about claims, right? And so we have this huge divide. I have no clear solutions. I just wanted to pose the problem. Just wanted to warn about the riptide of the third way. I wanted to propose a problematization, which Foucault said is a breach of self-evidence of those self-evidences in which our knowledges, acquiescence, and then practices rest. I just want to leave you with this final quote that is a translation from a book that I had as a student, a history book by Raffaello Aiello. Disjointed from responsibility, guilt and innocence fell under the dominion of fatal predestination. And similarly to Oedipus, who waited for the Pythia's oracles, the Christian of the barbaric age waited for his destiny of salvation or perdition at the manifestation of a will that, detached, transcended it. This is referring to medieval law. Basically, we're under the grace of God. We didn't know what it was our destiny. With enlightenment, when we set aside the God with human face, we took the responsibility of the world over ourselves. We claimed we can. It would be very ironic if, after pushing aside a God of the human face, we would now subject ourselves to the cold machinations of a distant God machine. Thank you.
Well, thank you, Jacopo. That was super interesting. I'm going to say a couple words, ask one question, and then I'll open it to the floor. First off, I just say thank you for that really useful problematization. We're at a point that I think everybody in the room is aware that AI is fundamentally changing so many aspects of our human experience, society, that we need to ask the right questions. And asking the right questions is sometimes even more important than answering those questions, because it diverts our attention to what is important and what we need to be thinking through. And you provided us with a really nice and interesting, I think, framework of this sort of tiered level of problems raised by AI for legal systems, your distinction between simple and hard, and then your sub distinctions within the simple or easy problems is helpful. So some people in this room are young and might not remember the movie Minority Report. We talked about it a few weeks ago, but in this movie, it's a science fiction movie where essentially there's an AI that can predict crimes, right? It's perfectly accurate at predicting who is going to commit crimes and when they will commit those crimes. And it's an action movie. But it raises some similar fundamental questions about the role of law in an era when humanity may or may not actually have free will, right? And so that's kind of where I'm going with this question, because there are some thinkers in the neurosciences who question our understanding of free will and whether or not free will is actually something that exists, or perhaps just a way for us to understand ourselves ex post, a way for us to explain our actions after we have taken them. And so the question I have for you, because your problem of AI in law, is you in parentheses, is it's a problem in law, but really it's sort of a fundamental problem of humanity in a post AI world. And so I think the question I have is, do you think the problem as you have posed it is distinct from or the same as a problem that arises in a world where we understand that humans maybe don't actually have free will and that our responses to stimuli are predictable? And if we had a perfect machine that could map out our brain waves, then we would be able to understand exactly what any human would do in response to any given stimulus. So are those the same problems or are they distinct problems? I'll let you wrestle with that.
Well, you really hit the nail on the head, because as a matter of fact, the more I'm writing about this, the more I'm just seeing that what I'm talking about is about the nature of identity. And what I'm talking about is about the problem of consciousness, the problem of human experience. And the problem of human experience, especially in a world that seems more and more computable, it is also the problem of how we desire, what we want, and whether we really want something. My intuition here, and I'm just trying to figure it out, so please bear with me, is that it doesn't entirely matter if we can predict what people will do, in the sense that what matters is our commitment to the things we do. In other words, it doesn't matter whether you are objectively right or objectively wrong, because for some things, I don't think that this kind of reasoning can be applied. What matters is that those things do matter for you. What matters for us in relation to reasons, and we go back to the point of reasons, is exactly that reasons reflect what you love. Commitment is another word for love. And love, commitment, I have an expressivist vision of it. You cannot really logically tell why you are committed to the things you're committed to. Like, for example, I recoil at the idea of imposing human suffering. I have no good reply to utilitarian arguments that say, yes, but if we impose human suffering, then other people will be better. And, I have philosophical replies, of course, but at the end of the day, I think that the huge gap is between what we love and what we don't care about. So I think that even if somebody can tell us that we are destined to love something or to don't love something, that love, that commitment will still be with us and will still matter for us. And it's useful to keep discussing about it because it expresses fundamentally who we are. Otherwise, you're probably in an even deeper hole that I'm thinking about now. I'm not entirely sure if I answered, but
I don't know that there is a perfect
answer.
Yeah. It's a complex set of questions we're dealing with. Are there any questions in the room or any comments anyone would like to make?